but Pascoe's coming up the road. Boots on the ground, heavy load. Yeah. Shining a light where the shadows grow. David Pascoe, South Carolina's own.
I'm honored to be here. I am the solicitor for the First Judicial Circuit, which is Calhoun, Orangeburg, and Dorchester counties, home of 3 of the finest legislators who just happen to be my constituents and can vote for me, Representative Cobb Hunter, Russell Lott, and Representative Robbie Robbins, none of whom I babysat either, I will add, in the past. I've been a prosecutor for 30 years now. I've tried hundreds of cases in front of magistrates, family court judges, and circuit court judges. I've argued cases in the Supreme Court. And I mentioned these trials, but I've also pled, had hearings and appearances in thousands of cases during my 30 years as a prosecutor. And I tell you all that because I estimate that I've been in front of anywhere to as many as 100 different judges in the state of South Carolina in the last 30 years, over 100. So take it from me when I tell you this, someone who's appeared before maybe about 100 different judges. We have good judges in the state of South Carolina. Some phenomenal public servants. You heard from a good one last week in Justice Kittredge. And I hope I'm not screwing up his vote in the next couple of months, but you heard from a great one in Justice Kittredge. Like any profession, we have some good judges, we have some bad ones, but the good far outweighs the bad. So I'm not here to bash the judiciary. I'm here asking to provide them a system where they don't have to look over their shoulders every time they make a decision to make sure that they're not offending a lawyer legislator or a member of the JMSC. I'm also not here to castigate lawyer legislators. We have some phenomenal lawyer legislators who serve us every single day in the legislature, many of them on this panel right here today on this committee. Some who've been my mentor for over 30 years, and others who I've butted heads with for 25 years, who I go to for advice often, because we have some great lawyer legislators in Columbia, and I appreciate that. The reason I'm here is because you can help us make the system better. Understanding that it's never going to be perfect, you can help us make the system better. I have had many judges, plural judges, in the last 2 years, as I've gone around the state talking about this issue, judicial reform, call and tell me, and this is a verbatim quote from one of them, any judge who tells you they don't worry about offending a JMSC member in their courtroom is lying to you. That's that judge's quote. I wasn't going to mention this, but Representative Bamberg got me kind of fired up. I had one judge call me recently, within the last 18 months, I believe, just to vent, almost in tears, to tell me he was forced to give a JMSC member a continuance in a civil case, wasn't even criminal, in a civil case, because he feared that if he didn't, he was going to lose his job when he had to go up in front of the JMSC just weeks later. And if you don't think that happens, hold tight and just wait and see what Solicitor Brackett and I have to talk to you about today. We solicitors hear it from the judges and the bar. They don't like the current system, but they're not going to stand up in front of you and tell you that when they have to go testify in front of the JMSC. With all due respect, Justice Kittredge, who I have incredible respect for, I was cutting my teeth as a prosecutor trying cases in front of him 25 years ago when he was a judge. He's still one of my favorite trial judges. But he got up here, and there was an editorial this weekend about that in the Post and Courier. The optics of him having to come up here and testify about the system the same day or the day after he has to go in front of the JMSC and ask for his promotion. As the editorial pointed out, the optics are bad. They're horrible. And Justice Kittredge, with all due respect, I've known him for 30 years. His DNA makeup, he's not capable of doing anything but telling the truth. Let me start with that. I know him, but he's got blind spots. He's got blind spots, and I'm going to talk about those. He's honest, but he's got blind spots. In a few minutes, Representative Caskey, I'm going to discuss that fidelity of facts that you called for so eloquently last week, that fidelity of facts, proving that the perception of our current system in the eyes of the public and even those in the judicial system is that it's not fair. It's not fair. Trust has withered away, and you can help by taking steps to rebuild it. I agree with Governor McMaster when he said that the public is losing its confidence in the way we pick our judges. I also, like Justice Kittredge, have spoken across the state about issues involving the justice system and judicial reform. And I can tell you, everywhere I go, whether it's the Rotary in Dorchester, Representative Robbins, the Rotary in Calhoun, Representative Ott, whether it's the conservative voices of Horry County, the Republican Party of Greenville County, or the Democratic Party of Orangeburg, everyone I talk to wants change in our system because they've lost confidence in the way we select our judges. The optics of our system are horrible, which is why the only people that I ever seem to hear defend the current JMSC process are the members of the JMSC and friends of the JMSC. But Representative Whitmore, when I go to Democratic Party functions, and I want to go with you to Charleston, bring me down there. Let's talk about judicial reform. Everywhere I go, Democrats and Republicans, 100% know we need to change the way we pick judges, and we need to change the makeup of the JMSC. Representative Wooten was so right last week. This is not a partisan issue at all. That's why Republican and Democratic voters across the state are ready for change. At least that's my experience when I talk to them. Last week, Justice Kittredge said he was intentionally not going to talk about lawyer legislators getting preferential treatment. But then he said they don't get preferential treatment. He specifically cited two high-profile cases as proof. The first one was Gerard Price, where the Supreme Court did rule against a lawyer legislator in a 3-2 opinion. And then the second case he talked about was Murdaugh, the Murdaugh trial, where he said, quote, ask Senator Harpootlian if lawyer legislators get preferential treatment. I want to talk about those two things briefly. Okay, so in high-profile cases, when the world is watching, we can count on no preferential treatment and no one being pressured into preferential treatment. But what happens when the world's not watching? What happens when the world's not watching? Well, we know the answer of that from one of the cases that Justice Kittredge cited, Gerard Price. Because when the world wasn't watching, a JMSC member goes back in chambers with the judge and the solicitor, Representative Mike, and I think it was you that brought that out. I'm glad you did. And the solicitor. But it's the JMSC member who tells the judge what he wants the convicted, dangerous murderer sentence to be reduced to. And the judge does exactly what the JMSC member did with regards to the sentence. And that came out during the Supreme Court hearings. I couldn't believe it. One of the justices asked, well, where did the judge get the idea on that sentence? And the JMSC member said, I told him to give him 18 years. And the judge then signs a secret, unlawful order. That's what happens sometimes with JMSC members when the world is not watching. And as for Senator Harpootlian, whether lawyer legislators get preferential treatment, it has been alleged that I am friends with Senator Harpootlian. And I'm not going to address that allegation at this time. But I will say that I went ahead and called him right after that. And I asked him that question, and I invite y'all to ask him the question. Anyway, you can invite him. But I'm going to tell you what he told me with a lot more tact and a lot fewer curse words. He said, yes, lawyer legislators get preferential treatment. It's not a secret. It's not a secret, which is why he, a Democrat, Representative Wooten, a Democrat, is about to pre-file legislation with a Republican. I saw him earlier. Maybe he might have ran out of here when I mentioned Harpootlian's name. But with Senator Wes Clymer in the Senate, a Republican and a Democrat sponsoring legislation together in the Senate to take lawyer legislators off of the JMSC. Everyone in the system knows about the preferential treatment, whether they want to admit it or not. Representative Caskey last week, and you are someone, I'm not picking on you because you are someone whose background I respect immensely, despite who your babysitter was. You grew up fine despite that. But you expressed frustration last week that the bar needs to defend the system better. But I submit the everyday hardworking lawyers that go to court across this state every day, they see it. They see the preferential treatment. Whether it's the public defender who sees the lawyer legislator getting their client a bond for violent charges that public defender knows they could never get, or whether it's that civil attorney who gets to their docket meeting early because the judge says we're going to go in order of arrival, just to have the judge let lawyer legislators skip the line and go first, even when you guys aren't in session. And even when it's not even the lawyer legislator who shows up for the civil docket, but one of their assistants from their office. It's preferential treatment that goes on every day in our courts because of our current system, which, by the way, now I'm going to geek out on y'all in a little bit. It runs totally contrary to Madison's suggestions in Federalist Papers 51 that Justice Kittredge cited. Before I forget here. The danger of this treatment, though, the most important part of what I'm going to talk about is that the dangers of this treatment is that it erodes confidence in what is supposed to be a fair system for everyone. Before I begin talking about specific examples, because unfortunately, Representative Ott, I do not want to be here. I don't want to talk about these specific examples. They don't make me feel warm and fuzzy at all. They make me feel very uncomfortable, but I'm going to give you some specific examples in a minute. But before I do that, I want to talk or touch on something that Representative Newton hit the nail on the head about in your opening remarks last week, sir. We have to have 3 separate independent branches of government. The perception, if not the reality, the perception is that we do not have that in South Carolina. Our judges, and the way we select our judges, runs totally afoul, totally contrary with Madison's Federalist 51 cited last week. And there's some of Madison's Federalist Papers 51. An independent judiciary is crucial to our republic and the separation of powers. But a judiciary cannot be independent when they are hired, fired, and solely funded by another branch of government. It's just common sense. Representative Robbins, you actually mentioned this to me many years ago, probably over a decade ago. You can't stand the term judicial department. It's the judicial branch of government. Over a decade ago, you told me about how they needed to be independently funded and needed to be treated as an independent branch of government. Under this system, the one we have, the judiciary arguably becomes an employee of the legislature, not a co-equal branch of government. And it's especially unfair when lawyer legislators who hire, fire, and fund these judges practice law in front of those same judges. So I was very pleased when Justice Kittredge mentioned Madison's Federalist Papers 51, because I haven't read it in years, and it gave me the opportunity to pull it up and read it, knowing full well that Madison would not approve of the way South Carolina picks its judges. Madison says we need to have 3 separate independent branches, and that, quote, the members of each should be as little dependent as possible on those of the others, of those other branches. He goes on to specifically say about judges, they are, quote, if they're not independent of the legislature in this particular, their independence in every other would be merely nominal. Madison would not approve of how South Carolina picks its judges. In fact, it was after reading that again last week that when I realized why we are only one of 2 states who pick judges this way. Because the other 48 states know that you can't pick judges that way because it's a total affront to how our founding fathers in Madison said we should pick judges. Now that's your history lesson today. That's Representative Newton's fault and Justice Kittredge's. But let me also be clear about this, Representative Thigpen. We're not here asking for drastic change today. We're not asking for drastic change in our process. We're just asking for common sense, easy statutory changes that will help maybe restore confidence in the system that we have today. We're asking that you remove legislators and legislative control from the JMSC. Change the way the legislature votes. That's it. We're not asking that legislators not elect judges anymore. We're just asking that you remove legislators from the JMSC. This is not drastic change. It's not drastic change. Right now, I'm going to talk to you about some specific, and I try to keep them almost all fairly recent. I didn't want to go back decades. Instances of preferential treatment, and in my opinion, bad JMSC actions. I know, I'm not going to hold back. Rotten JMSC actions. You're going to hear some rotten actions done by the JMSC prior to you getting there, Representative Caskey. But I want to reiterate that I'm not alleging anything unlawful, nor am I wanting or trying to prove that any of these things I'm going to discuss are a crime or that I would try to prove they're a crime because they're part of our system. But what I can prove to you beyond any doubt, not just a reasonable doubt, but beyond any doubt, is that in these instances I'm going to discuss with you, they do undermine the public and the bar's confidence in our justice system. And sometimes, unless you press for it, I will not mention the judge or the legislator involved unless you press for it, although oftentimes I will be mentioning the lawyer, legislator, and the judge because I have to. But there is one instance where I will not share the name of the lawyer, legislator, or judge merely because we just found out about this, the solicitor, not 10 days ago, and we're seeking ethics advice on whether to file a complaint or not. All right, let's get started. Let's talk about the most obvious form of preferential treatment that lawyer legislators get, which is protection from going to court. For you non-lawyer legislators who have to go to work when you're not in session, our court that has to go before a JMSC, that has to be elected by legislators and who gets their funding from the legislature, currently gives lawyer legislators 7 months of absolute protection from court. From January 1st through July 31st, no one can order a lawyer legislator into court. And after July 31st, if that legislator is in session, like Representative Robbins is now, obviously he has protection and obviously he needs that protection. So from January 1 through July 31, with rare exception, lawyer legislators cannot come to court. And I am not saying that lawyer legislators should not get protection. They absolutely should get protection. I'm just saying that when it's to that extreme, it leads to abuse. And we're going to talk about those abuses in a minute. Back in January of 2002 on a Thursday, I talked about the abuses this protection creates and the horrible optics of it. How a defendant and how defendants know how to play the game in the system. I talked about how my office had a CDV hand, a criminal domestic violence of a high aggravated nature case, ready for trial, witnesses ready to go. But on the eve of trial, defense counsel co-counseled a lawyer legislator, and the judge was forced to grant a continuance. She had no choice, didn't want to grant a continuance, but had to. That's preferential treatment for a defendant and for the lawyer. Around the same time, Solicitor Wilson's office had a very serious felony DUI set for trial for January. It had been set for months. It had been set for a while with the victim's family members coming in from across the country to attend. But 2 or 3 weeks before that trial date in January, 2 or 3 weeks before that January trial date, lead defense counsel announces, no, we aren't going to trial. The judge didn't grant the continuance. Who's supposed to control the docket, Representative Bamberg? The attorney did, because the attorney said, I have assigned a lawyer legislator for my office, and he's protected through July. The case had been pending for nearly 3 years when the lawyer legislator was assigned to that case on the eve of trial. 3 years. The head of the firm, a renowned criminal defense attorney, then announced that he was assigning all of his criminal cases to the lawyer legislator. So he told the judge and the lawyer legislator, all of our cases are continued until after July the 31st. And Judge Jefferson, a judge I have incredible respect for and have known for years, had no choice but to continue the cases. But there's another backstory to these cases which shows you that Judge Jefferson did get the last word in doing the right thing, that there are judges who always stand up to lawyer legislators. After the legislator's protection ended, the defense attorney's client was then, of course, miraculously about to plea. They were going to go ahead and plead guilty and take the state's plea deal. And actually, they didn't take the state's plea deal. And if you look in emails, let me get ahead of myself. State versus Thomas Garris. It's all public record, and I'm not going to go over the entire case with you. You guys are more than welcome to look this case up or get your staffers to. There are actually emails where the defense attorney and the lawyer legislator say, hey, we can get our friend Judge Bentley Price, will take the plea. Judge Jefferson said, no, it's not going to go in front of Bentley Price. It's going to go in front of another judge. And the case pled in front of another judge, and it has already turned into a little bit of a mess. And one of the reasons for that mess, I'll just tell you, is because of the lawyer legislator's involvement. And again, I would invite you, read the emails, read the text messages that are part of the record, and how promises were made to the defendant because they could get a better sentence from the judge because the lawyer legislator supported that judge and got them elected. Another matter I spoke about in the past concerning abuse of lawyer legislator protection involved a defendant out on bond for robbery, rearrested for drugs in December. Their bond revocation was going to be heard in January. The defendant hires a lawyer legislator, and the lawyer legislator says, you can't call my client's case in January now for that bond revocation. Criminal defendants know how to play the system if they have the money to hire a lawyer legislator. And again, honestly, I don't see how anyone can say, and that's why Harpootlian said it with certain words, yes, lawyer legislators get preferential treatment. Let's not deny that. This is the Chief Justice's, let me make sure, order. So after I complained about lawyer legislator protection on Thursday in January, it was reported on Friday. Lo and behold, on Tuesday, the Chief Justice sent out another order, Chief Justice Beatty, saying, lawyer legislators, you no longer get full protection. You are now going to have to come to court for cases that are over 3 years old. The trial judge can call your cases for court if they're over 3 years old. I was extremely pleased with Chief Justice Beatty for doing that. Whether it was because I was complaining about it or not, he made the decision. The next day, I called a state senator and we discussed it. This would have been on Wednesday. And he commended it. But the senator said, we'll see how long this lasts. We'll see how long that order lasts that was signed on January the 11th, telling lawyer legislators they had to come to court for old cases. Because that state senator had run into a Ways and Means lawyer legislator, not the chairman at the time or now, but they had run into a Ways and Means lawyer legislator, and they were complaining a lot about Chief Justice Beatty. And I remember telling that senator, tough, it's an order now. That legislator's just gonna have to live with it. So my office was putting together bond revocations and old trials, 3 years or older, with lawyer legislators on the docket when the judge calls me and says, Solicitor Pascoe, we can't put these lawyer legislator cases on the docket anymore. And I asked, what are you talking about? Chief Justice Beatty just signed an order about this. And the judge said, well, on the very next day, on January the 12th, the same day that legislator on Ways and Means complained to the state senator about the order, the Chief Justice had Court Administration send out an email saying, ignore my order. The very next day. Now, I can't tell you why he rescinded the order in just 24 hours, but I can tell you what my perception was. And I can tell you what the perception of that state senator was when I talked to that senator later. I don't think I have to say it out loud, because it's also the perception the judges and members of the bar had as to why that protection was rescinded 24 hours later. And Representative Bamberg, who controls the docket in the state? The courts. The chief administrative judge of civil and criminal courts are ultimately in charge of the order of the cases in South Carolina. It was Langford where our Supreme Court said that we cannot let another branch of government control the docket because of separation of powers. That's the judicial branch's role, Representative Bamberg, and I agreed with that. Guess what? I'm the one who did the oral argument, or part of the oral argument in Langford, and I agreed with that. Solicitors should never have, and I said this 12 years ago in front of the Supreme Court, last word on any case. The last word, the word that matters, should always belong to the courts. That's the separation of powers. But in South Carolina, the chief administrative judge for the circuit does not control the order of the cases with the lawyer legislator or the calling of the lawyer legislator's cases. And this transcript from State versus Larkin proves that. Representative Stavronakis from Charleston had 3 cases on the docket, but he's protected from the court because the General Assembly was in session, but y'all weren't in session, I guess, that day, and he came to court. And he went in front of a very good judge, Judge Roger Young. And Judge Young tells Representative Stavronakis, we were told that the Larkin bond revocation, which, to let non-lawyers know, that's a risk of having your client locked up that day. When there's a bond revocation, the solicitor is asking a judge to lock that defendant up because they've gotten back in trouble. But Judge Young tells Representative Stavronakis, we were told that the Larkin bond revocation isn't going because you're protected. Representative Stavronakis replies, that is correct. Judge Young then states, okay, why are you here? So if you're protected, why are you here? At which time, Representative Stavronakis, all in the transcript, tells Judge Young that he's here to waive protection on a guilty plea he wants to do, but he's refusing to waive his protection on the 2 or 3 bond revocations he has in front of Judge Young. The lawyer legislator is directing the judge how to call his cases. There's a problem with that. And Judge Young goes on to say, I haven't seen that order, but that doesn't seem like it's in the spirit of things. But ladies and gentlemen, there's nothing the judge could do. That is wrong. And let me ask you this. How do you think the optics were of that exchange for not just the judge and the solicitors and the attorneys and the public defenders, but also the victims and the defendants in that courtroom? Think about that. I know you're a judge, but you can't lock my client up today. I'm here because I want to do a case, but you can't lock my client up today because I'm a lawyer legislator and I'm protected. All right, this is another specific story that the solicitor and I just found out about very recently. This next instance I wish to discuss happened earlier this year, but again, we just found out about it within the last 10 days to 2 weeks. A judge put out word that the judge needed to speak to the assistant solicitor on a case. The assistant solicitor went back in chambers, and the judge told the assistant, I'm friends with the JMSC member. He represents this defendant. He wants to be here for his bond hearing but can't make it. What's the defendant charged with? The assistant solicitor says, trafficking heroin. The judge immediately says, well, I'm going to give him a bond. I mean, never mind that the defendant was convicted of voluntary manslaughter and got a 20-year sentence in 1992. Never mind that he has a 2007 trafficking heroin conviction where he got 7 years in prison. Never mind that he was already out on possession of drug charges when he picked up this trafficking heroin that the JMSC member called the judge about because he can't make it to the bond hearing. Never mind that he's facing life without the possibility of parole. Before the hearing, the judge says, I'm going to give him a bond. But it gets even stranger. Somebody tell me that a non-JMSC member has ever been able to do this. The judge in chambers gets the JMSC member on the phone, It says, we're going to do the bond by phone. And the judge has his cell phone taken down to the holding cell. So the convicted drug dealer and killer can use the judge's cell phone to talk to the JMSC member, his lawyer. I've heard a lot of crazy stories in my time in 30 years, but I've never heard of a judge allowing a convicted killer and drug dealer use his phone while he's in a holding cell. Never mind the issue about the potential of illegal contraband to a defendant. And I've never heard that happen with another lawyer, but it happened for a JMSC lawyer and his client. The deputy then brings the phone back to the judge. They go back out in the courtroom and they set bond with the judge holding the cell phone up for the JMSC member to hear it, and the defendant got a bond, and he is now out on our streets. There are a lot of problems with that preferential treatment case. A lot of problems. This is one that we've all heard a lot about, and it came up today, Gerard Price. And again, in recent months, unfortunately, we've heard about a lot of crazy cases involving Representative Rutherford for whatever reason. More than this, I think there's been 3 or 4 cases that have been reported in the newspapers about Representative Rutherford. And I can tell you, it just seems like all the bizarre cases that we see as solicitors always involve lawyer legislators. Weird ones like this. Todd Rutherford, representing a dangerous convicted gang murderer, goes back in chambers. The judge asked me, with the solicitor, who goes along with it. And the judge asks, what do you want me to sentence him to? Rutherford tells him, and the judge gives it to him. And then they all agree to sign a secret order to be sealed forever. I know the victim's parents, Carl and Lily Smalls. I know them very well because I tried Gerard Price. They deserve better from our justice system than that. An automated call telling them that they know, to let them know that their son's killer is going to be released early in the next 2 hours. And they didn't know where to turn. They went to the solicitor's office, who couldn't help. They went to the governor's office, who did not help at that time and couldn't help. Nobody could help because it was a sealed secret order. And yes, I agree with 3 of the justices out of 5. It was a remarkably egregious set of facts. And then once it's exposed, Carl and Lily Smalls had to listen to a JMSC member talk about how Gerard Price is a victim. It was outrageous. I've tried a lot of murderers. I've put people on death row. Price is the only defendant that I've had to get an armed escort from the courtroom to my car and back when I tried him. That's how dangerous he is. And I was in the garage, and I had to get an armed escort, not of my wanting. When he escaped, Chief Keel called me to tell me we need to do an analysis or whatever on this guy. Where are your kids? Asking me where my children are. That's how dangerous Gerard Price is. But to JMSC member Todd Rutherford, he was a victim. And then we read about this case, the second one, and the last one I'm going to talk about about Todd Rutherford, just months ago. And again, why is it all the weird cases involve lawyer legislators or JMSC members? He pleads his client to a drug charge carrying a mandatory minimum sentence. His client already had multiple drug convictions, drug trafficking convictions, had already been to prison before. And Rutherford is able to convince a judge to allow his defendant to remain out on bond after his guilty plea. This multiple convicted drug trafficker is going to get to stay out on bond after his guilty plea to get a pre-sentence investigation or a PSI. 30 years, I've never heard of someone who's been to prison on multiple occasions getting a PSI for drug trafficking. Never seen it. But it gets worse. Oh, and of course, and let me point this out. By giving him the PSI, it's no secret. The plea was in the month of December. It was in the month of December. The pre-sentence investigations aren't going to be done until January or February. So what does the PSI allow the defendant to do? Stay out on the streets until at least August, because you can't order Todd Rutherford back to court even to sentence a defendant who's pled guilty to drug trafficking. No preferential treatment. But it gets even worse, because not only did the defendant not come back in August, he stayed out long enough to pick up a domestic violence charge in another county and get out on bond again. The defendant wasn't sentenced in August. He wasn't even sentenced that year. He wasn't sentenced the next year. He wasn't sentenced the year after that. It took 3 years before they were able to get him to court and get him sentenced. And sadly, if this hadn't been reported in the press, I'm not so sure the defendant would have been sentenced today. This just happened back in August. If it hadn't been reported in the press, I don't know that he would have been sentenced back in August. This is a very minor issue in my circuit, and I'm just mentioning because it's so recent. We filed this yesterday. Again, why do strange cases always involve lawyer legislators? And honestly, we could spend a day talking about other cases just like it. But this other one, we filed a motion. The defendant pleads guilty back in October of 2022. And before I go further, the judge on this case is a great judge. The lawyer legislator on this case is a great lawyer legislator. Best you could ever deal with as a solicitor or an attorney. But the state recommends a brief prison sentence at his guilty plea in October of 2022. The lawyer legislator asks the court to accept it, the judge accepts it, and the defendant is supposed to go off to prison to serve their sentence. That was 13 months ago. However, the judge accidentally writes the wrong sentence, and the defendant gets out early. It was an accident. He wrote down the wrong sentence. There is no doubt, it was in my mind, that it was an honest mistake. But when we bring it to the judge's attention that you made this mistake and that the case law is clear, your oral order of the sentence controls the sentence, so just please amend your order so the person can go back to prison, the judge won't sign it now because the lawyer legislator objects. So now, 13 months this has been going on, and we've had to file a motion, put it to paper, to try to get the judge to bring this defendant in and get this person back in prison. It's just another example of how the optics are bad. And don't forget, there are victims on this case. This was an important case to them. And they see that their defendant is out when they shouldn't be out. This is Judge Christy Harrington, and I'm going to talk to you about her experience with the JMSC. And this is important, Representative Caskey. I want you to hear what happened to Christy Harrington, and I'm glad Representative Rutherford's here because he can hear it too. Back in March of 2022, I'd already spoken about the need for judicial reform in Greenville and Newberry and other places. And I, like many members of the bar, had heard rumors that the reported reasons for judicial candidates, especially sitting judges, dropping out of races at the JMSC level is not the whole truth. I'd heard those rumors. The perception amongst my peers and other members of the bar is that there's always a backstory involving a disgruntled JMSC member. A JMSC member who had a judge in their line of sights and they wanted to take him out. So that March, I decided to start reaching out to those judges who were forced out of the JMSC or forced to withdraw. Many of them talked to me, and they had fascinating facts and stories to tell me, but only 2 would let me tell their story publicly. One of them is here today, Judge Tommy Russo. The other one, Christy Harrington, wanted to be here today, but she's litigating a case out of state. I actually had one former judge who wanted to come to my office with documents. They reached out to me. Yes, Pascoe, I want to talk to you about it. I'm going to bring documents. They requested the in-person meeting, but in the morning they were supposed to come. They called me and apologized and said they couldn't go through it because they feared retribution because they still practice law. But the 2 former judges that did allow me to tell their stories were Christy Harrington and Judge Tommy Russo. Last week it was discussed how the JMSC, quote, weeds out bad judges, and that the JMSC should be commended, not condemned, for not having bad judges reelected. I could not disagree more. The JMSC process is rigged, and a process that I can't even understand the rules of, because they seem to change depending on the candidate, and I can tell you that from my own experience in dealing with the JMSC. And it contradicts the purpose of what being qualified means. Justice Kittredge told y'all last week, it's a low threshold. And yet the JMSC member deprives you, every member on this panel, the right to vote up or down on a judge like Judge Harrington when they have them in their line of sights. The JMSC does not weed out judges. They berate them, they threaten them, and they intimidate them until they drop out. That is not a system we should support. Judge Harrington, who I knew, and I knew her very well, my lawyers knew that they had to be prepared when they went into her courtroom and that she was fair, that she was no nonsense. She was known for her unequaled work ethic. In her 10 years on the bench, she tells me she presided over 250 jury trials to verdict with a 96% affirm rate when she went before the JMSC in 2017. Interestingly, former Judge Harrington, to this day, still teaches ethics at the National Judicial College in Reno, where you pay to send our judges to learn ethics. She teaches them ethics. She served as the chair of the faculty committee and has been on the board for 6 years after she went through her JMSC experience in the fall of 2017. So we're going to talk about her experience, and very importantly, again, she wanted to be here but couldn't. In the summer of 2017, Judge Harrington had filed for re-election. She had already been elected and re-elected on 2 other occasions to be a circuit court judge. On a Friday in late August of 2017, on that Friday afternoon, or sometime in Friday, an assistant solicitor went to her for scheduling purposes because they had a murder trial scheduled for Monday, and the defense attorney wanted a continuance. On the eve of trial, the defense attorney wants a continuance. Judge Harrington was the chief administrative judge, and it was her job to set the docket and to set the trials. The murder trial had already been continued on previous occasions because of the attorney. It involved out-of-state witnesses, and the family was set to come for the trial on Monday. And the defense waits on the eve of trial to ask for continuance. So with the assistant solicitor in chambers, Judge Harrington called the attorney. The attorney at that time was JMSC member Peter McCoy. He was on the JMSC when he was asking for that continuance on Friday. He asked for the continuance. The judge explains to him that it's an old case. It's been continued before. It involved out-of-state witnesses. It's the 11th hour, and it's not right to ask for a continuance unless you have a good reason. She asked Mr. McCoy, do you have legislative protection next week? And he said no. And she said, you need to be here Monday. But Mr. McCoy then responds, that's Judge Murphy. I don't want to go before her. Harrington says, sorry, that's the judge on Monday. I want to divert away for 2 quick points, and then we're going to get right back to Chrissy, and I'm going to tell you what happened to her, Judge Harrington. First point I want to make is that's Judge Murphy, that's our judge. And she's as fair and as good as any judge there is in the state. It seems to me, Representative Whitmore, that we maybe need more women on the bench, because the 3 judges that I'm talking about who have stood up to lawyer legislators seem to be Judge Jefferson, Judge Murphy, and Judge Harrington. Yet, I'm told we're the only state in the union that doesn't have a woman on the Supreme Court. I think that is evidence enough why we need to change the system in one way or another. I'm also told, Representative Thigpen, that come this July, once my friend Chief Justice Beatty is gone, we will not have one person of color on the Supreme Court. And that we will only have maybe one person of color of the 14 appellate court judges in the state of South Carolina. Honestly, that by itself is drastic evidence as to why we need some kind of change with our system. I don't understand why we're defending this system. It makes no sense to me other than to help people out that want to keep their power on JMSC. And again, I'm not asking for drastic change. I'm asking for lawyer legislators to be removed from JMSC because of what happened to Judge Harrington. Let's get back to her. She tells Peter McCoy no continuance. She knows Peter McCoy's upset. And not long after she hangs up the phone with Mr. McCoy, she immediately calls another circuit court judge, a good friend of hers, and says, I'm in trouble. I didn't give Peter McCoy a continuance, and I think I'm in trouble. I think he's mad at me. Representative Newton, that is not an independent branch of government. That is a judiciary scared that they're not going to get to keep their job because they offended a JMSC member right before she has to go in front of the JMSC. That story by itself, if it ends right there, is why we have to take lawyer legislators off of the JMSC. That story by itself, calling another judge, I'm in trouble because I upset a JMSC member. That is not an independent branch of government. That is not what Madison condones in how we pick a judge. We have judges scared because they don't want to offend JMSC members. The following Tuesday, that was on Friday, on the following Tuesday, Judge Harrington gets a call from Representative Leon Stavronakis. And Leon Stavronakis tells Judge Harrington, what did you do to make Peter so mad? I was with him in Merle the other night, and I've never seen him so mad. She knew then, again, she's in trouble. And she called her JMSC lawyer, who told her, you don't have anything to worry about. You're unopposed. No one has filed an official complaint against you. You got this high bar standing from the Citizens Committee, you got nothing to worry about. But she knew she did have something to worry about because she offended a JMSC member. The hearing comes along, I think it was November, December, and it was brutal. There are all kinds of articles about it. They berate her, they threaten her until she withdraws. At some point, a member of the JMSC member sitting in the back right now read Judge Harrington her rights. Her rights. First, they accuse her of being mean. When that didn't pan out, they accuse her of having debt and too many student loans, which ended up being paid off within the next year or two. The JMSC member sitting in the back mocked her and told her she couldn't afford a sandwich. When that didn't pan out because her credit score was too high, they said she had contact with the legislator. And when that didn't pan out, they turned to intimidation. They threatened her, and she dropped out. They intimidated her to the point where she had no choice but to drop out. Read the articles. It's brutal. That is not a system we need to be proud of. And in my many conversations with Judge Harrington, she would always tell me that there were people that saw what happened, David. And she would tell me that John Nichols, the director of the Office of Disciplinary Counsel, was in attendance. And she told me, David, she told me this just last week, he apologizes to me every time I see him. And then she told me other things that John Nichols told her. So last Friday, I decided to call the former ODC director. Even though I trust Judge Harrington, I knew she wouldn't lie to me, I decided to call him because I wanted to make sure that what I'm about to tell you is right. When I say that what happened to Christy Harrington is that the JMSC that day was rotten to the core. Rotten to the core. And I promised John Nichols last Friday that I wouldn't quote him directly, but I now feel very confident in quoting Christy Harrington. John Nichols was asked to come to Christy Harrington's hearing by a JMSC staffer. He didn't even know what it was about, but he figured I'm about to be the director of ODC. I'm invited, I need to go. Invited by a staffer. He got there, he sat in the back, and before Christy's hearing got started, Chairman Luke Rankin asked John Nichols, no, come down and sit on the front row. The JMSC manipulated John Nichols, the director of ODC, to sit on the front row to intimidate Christy Harrington because she said when she saw John Nichols, she knew it was over. They were coming for her. John Nichols has since according to Christie, on multiple occasions apologized to her for letting him be used for this injustice. She was in their sights and the fix was in. And what proves that even more, and I'm going to finish right here about Christie, what proves it even more, Ms. Harrington, is that do you know that after the JMSC threatened and intimidated Christie Harrington from her post, after they read Miranda rights to her like she was accused criminal, after they called her unethical, do you know who brought Christie Harrington on as an assistant to the office, a disciplinary counsel to handle complex disciplinary and ethics issues? John Nichols. Weed out bad judges? Commend the JMSC? No, condemn the JMSC. So she's not qualified to be a judge in South Carolina, but she can teach our judges and she can handle complex ethics issues. And I'm going to tell you something else that I wasn't planning on telling you, and that she doesn't even know about it. Only Solicitor Scarlett Wilson and Judge Diane Goodstein know this. They reached out to me, Solicitor Wilson and Diane Goodstein, asked me to go to Judge Harrington's hearing back in 2017. Solicitor Wilson couldn't go because she was in federal court and couldn't attend. Obviously, Judge Goodstein couldn't go, but I think her husband went. I might be wrong, but I think he went. They knew she was being treated unfairly. I think they knew the inside baseball a lot better than I did. And they thought for whatever reason, maybe I could go and help. And I told them I would try reluctantly because I wasn't as close with Judge Harrington as they were. And I didn't know all the circumstances. But right before I headed to Columbia, I spoke with the JMSC member. I was literally walking out the door and the JMSC member said, "Don't bother coming. She's done. She's toast. Nothing you can say is going to help her. We want her gone." So I didn't go. I wish I knew then what I know now, because I sure as hell would have gone today. About perception, Representative Caskey, I was just doing some research on Christie Harrington's race, looking for articles. And I saw this op-ed for the first time last week. It was an op-ed written by Mr. Roy Willie. I think he's a Charleston attorney, Representative Whitmore, but I'm not sure. I think he does a great job of explaining what the everyday member of our South Carolina bar thinks about the JMSC and our process of picking judges. He said, "As attorneys, we believe in due process. Judge Harrington's process was an all-male commission that badgered and forced her to withdraw." He further goes on, as far as optics, to say, "Legislators electing judges is a strange thing, and it seems to me that this situation is a very good argument against it. Watch to see if a legislator or spouse of a legislator is picked to fill Judge Harrington's seat. That will tell you most of what you need to know about the politics of the process." I'm not saying it's true. I am saying what happened to Christie Harrington is an injustice. But I'm not saying any of that is necessarily true, what Mr. Willie said, but that's the perception of the JMSC process in South Carolina. That's the other problem we have with our system. People see legislator spouses, siblings, children, law partners, cousins, best friends getting elected. And it taints the process for everyone else. It taints the process for great judges like Maite Murphy, who's, in my opinion, one of the best judges in the state. But it taints it for her. And Mr. Willie was wrong. Mr. McCoy's spouse didn't get elected in just Judge Harrington's spot, but only because she got elected that year in another spot. And people just roll their eyes about it, even though all I hear about Judge McCoy is fabulous things from Solicitor Wilson and others. But people still roll their eyes. But instead of electing his spouse, who his said was already being elected, we got his best friend. We got one of his best friends, Bentley Price. Mr. McCoy spoke at length for anyone who was at Bentley Price's investiture. He spoke at length about how he worked hard to get Bentley Price elected to the bench. Judge Price has been in the news a lot lately because of questionable judgment. And at times, the attorneys on those questionable cases have either been Mr. McCoy or another legislator. In fairness to Judge Price, this opinion piece done on him a couple of weeks ago, criticizing him for dismissing a pedophile's charges, did not involve a lawyer legislator. I don't think it involved a lawyer legislator. But this recent case just a couple months ago, and again, I'm just talking about recent cases. This recent case just a couple months ago does involve a lawyer legislator representing a defendant charged with murder. The defendant's name is Dartez Ferguson, Jr. There are several other stories, including one very recently on Live 5, of how disrespected the victim's family felt in Judge Price's courtroom. Leon Stavronakis, lawyer legislator, represents Mr. Ferguson. The state moved in April to revoke Mr. Ferguson's murder bond because they believed they could establish he was violating his GPS requirements. It was scheduled to finally go before Judge Young, who we talked about earlier, this summer. April, think about that. Finally going to get to the bond revocation sometime, I think it was in late July. Representative Stavronakis, though, didn't want to go in front of Judge Young and emailed Judge Price, who is the chief administrative judge, and was able to get Judge Price to continue it to a later term that Judge Price presided over. Judge Price heard both sides and decided he would make a final ruling in about 10 days to 2 weeks later when he would get more information. But he did say, and this was on the news for the world to watch, it was on video on the 6 o'clock news. He said, but I'm revoking the defendant's bond until we get to that hearing in 10 days. And then the news reports showing it, but Leon Stavronakis protested, and the judge changed his mind, and he allowed the defendant to stay out on bond. The victims were present. Again, the judge said that they would reconvene in a couple weeks, but they never did. Instead, after some email exchanges with the prosecutor and Representative Stavronakis, Judge Price signed an order letting the defendant stay out on bond. So he's still out on bond. This is far from Judge Price's first act of preferential treatment of Representative Stavronakis, and I would invite all of you, go to the Ninth Circuit Solicitor's Office's website for the public to see, all of you to see, what the bar, the bailiffs, and everyone in the courtroom see every day, which is preferential treatment that he gives to Representative Stavronakis. Justice, I keep calling you Justice. Representative Bamberg, you want specific judges, I'm giving it to you. And I'll give you, this was another case that now involves my circuit. It involves both the Ninth Circuit and my circuit, and the defendant's name is Savion Scott. Again, very recent, just happened in the last month. Mr. Scott is arrested on 5 separate occasions for mostly drugs, always bailing out in magistrate's court. He was out on 5 bonds totaling $135,000. Remember that number, $135,000. In September of 2022, he was charged in Charleston County for attempted murder and a slew of other charges for allegedly firing a gun into a crowd in downtown Charleston. And his bond was denied by the magistrate, so he's finally in jail, bond denied. 5 charges, now he's picked up a 6. The state moved to revoke all of Mr. Scott's previous bonds that totaled $135,000. And of course, the state was asking that his bond stay denied on the attempted murder. The hearing was set for January the 3rd. And honestly, I don't know that I ever would have thought that a judge would have let this defendant back out on bond after the attempted murder. And I mean that. On January 2nd, the day before his bond hearing in circuit court, former JMSC member Peter McCoy, who told the world he got Judge Price elected, filed a motion to set bond on behalf of defendant Scott, and that McCoy's appearance was, quote, limited for appearance for bond only. He wasn't even going to represent him on his charges. He was just there to represent him to get a bond. And I don't know that this is true, but I am told that at the bond hearing, he didn't even say a word. He just stood with his client. I'm still waiting on the transcript of that. Because they have the hearing on January the 3rd, and not only does Judge Price not revoke the 5 other bonds that were totaled at $135,000, not only does he refuse to deny Mr. Scott's bond on the attempted murder, he literally totals all of his bonds for just $100,000. It's the only defendant I've ever known to get rewarded and get your bond lowered for allegedly committing attempted murder. $135,000 to $100,000. Now, he did put him on electronic monitoring, which was good, because I think it does help us in our Dorchester case, because a few months later, Savion Scott was arrested for murder in my circuit in Dorchester County, out on that $100,000 bond by Judge Price. This is the judge that JMSC member McCoy got on the bench after they berated Harrington into dropping out. Judge Price goes before the JMSC today. Will he be weeded out? Will they ask him about news reports on Live 5 about how he rolls his eyes at African-American victims in his courtroom? Will they ask him that? Will they badger him the way they badgered Christy Harrington about her student loans? Will they badger him about his questionable expenses? I guess we'll find out this afternoon. The last case I'm going to talk to you about, and I promise I'll shut up, is another recent one involving Judge Daniel Coble here in Richland County. And again, it's not about whether it's a good ruling or the right ruling. It's about the optics of what happened here. Y'all may recall there was that big $75 million case that was brought up. One of the lawyers was a JMSC member, another one's a state senator. And Judge Coble ruled in favor of the JMSC member and the senator. Did he rule correctly? I don't know. I'm not a civil lawyer. I don't know. But I know that the optics of it looked horrible because Judge Coble is going in front of the JMSC member this week, or went last week in front of that JMSC member. I mean, a week before he has to go in front of the JMSC, he's ruling on a case involving a JMSC member worth millions, a case involving millions and millions of dollars. The optics are horrible. He shouldn't be put in that position. And it was reported in the news about how he just made this ruling for that party, and he has to go in front of them in the next couple of weeks. It was in the paper. He shouldn't be put in that position. And unfortunately, there's another backstory to it that makes what happened in that case even more suspect in the eyes of many members of the board. I think many of you will remember this fiasco involving Judge Strickland. The Richland delegation tried to unlawfully ouster him. It was absolutely nuts. It was crazy. The delegation convened, failing to adhere to the FOIA laws by not providing 24 hours notice before they took that vote to ouster Judge Strickland. They met anyway, voted to ouster him. One question that some in the bar had was, why didn't Strickland or one of the legislators who supported him, why didn't they try to get a temporary restraining order hearing, a TRO hearing, to stop the vote? Well, they tried. And the lawyer, Chris Kinney, is willing to come here and testify to you anytime you want to hear from him, Mr. Chairman. He says he's willing to come testify to what I'm going to tell you and more. He tried, but he was denied not just the temporary restraining order, and he was denied the hearing. The delegation meeting was to begin at noon with legislators, a lot of lawyer legislators. Chris Kinney got to the Richland County Courthouse at approximately 9:15. 9:15 in the morning to have a quick emergency hearing in front of a circuit court judge to ask for the TRO. And these are matters, any TRO, it's usually a matter of pressing urgency. Got to get it heard. Happens every day in courthouses across America. Getting a circuit court judge to simply have a hearing to determine whether the legislature should stop doing something Getting that hearing is a simple thing to do when you have a separation of powers and the judge doesn't have to worry about offending legislators that he might be signing an order against. But not for a judge who's up for re-election. Mr. Kinney gets to the courthouse at 9:15. The judge he needs to have that quick hearing in front of is Judge Coble again. Judge Coble is in chambers. Mr. Kinney will tell you the clerk's office was awesome. They went back there, told the judge, got Mr. Kinney out here, pressing matter, has to have a TRO hearing. You got to decide whether to grant it or not. 9:15, 9:30. He had those documents in his hands, Judge Coble, no later than 9:30. Remember, got to have the hearing by 12. Have the judge decide yay or nay. 10 o'clock, the judge stays in chambers with the door shut. 11 o'clock, the judge stays indoors in chambers and still refuses to see Mr. Kinney. 12 o'clock, the judge stays in chambers. Law clerks and clerks of court were going in there to try to get the judge to see Mr. Kinney, knowing it was pressing. Finally, at 12:15, the judge opens the door, sees Mr. Kinney, and says, "It's too late now. The meeting has already started." That is not exactly an act of a profile in courage. I mean, just give the man the hearing and give it up or down. 3 hours. He made him wait, and it appears in the eyes of Chris Kinney, who had a conversation with the judge, a very heated conversation at 12:16 p.m. It appears that he intentionally made him wait to make the issue moot because he didn't want to decide the issue of whether he should grant a TRO against those legislators or not. That is why Madison says you can't pick a judiciary dependent on the legislature. That is why so many people question whether we have an independent judiciary. And it encapsulates why people have lost their interest, Mr. Chairman, in our system. I had an eloquent 20-minute close that I was going to do, but I'm going to pass it over to Solicitor Brackett now.
We're going to divert just a little bit because you've gotten all of my members so excited. They're
good.
chomping at the bit. So, Mr. Brackett, we're going to come to you in just a moment. I will admonish both sides of this not courtroom that we're going to have some decorum. I know these are contested issues and heated issues. I want each, the questioners and the answerers and vice versa to respect each other, or we'll cut the questioning and the answering short in that regard. So, thank you. Mr. Caskey has first question.
Thanks, Dad. That is an admonition that I have brought on by, let's say, custom and habit. Solicitor Pascoe, I want to just first acknowledge that you have offered many critiques that merit further consideration, that are worthy of our time and thought. And I'm not here to dismiss those out of hand just because I have more questions about what you've offered. And let me also thank you for your service to the state as a solicitor. I respect that and am grateful for it. And I'll also add, because I think it's relevant to some of the points you raised, that pressing people in power is always difficult. It's always a challenge, and I might need to fly to Charleston from now on to make sure that I don't find myself on the other side of this. But your remarks left me with one recurring thought, and that was that I am so grateful that in the court of law we have the confrontation clause, that our Sixth Amendment gives us an opportunity to challenge the things that are offered, because as you talked, I don't know how anybody could not vote to convict. I think, though, because you talked about optics, we ought to think about what that really entails, what that really means. And optics, another word for it might be presentation. How is it presented to the decider, the decision maker? And again, I can understand why you would be particularly emotional in a case like Gerard Price. I would probably quibble with you that it wasn't 3 of 5 justices that said that was egregious conduct. As I read Justice James' dissent, he clearly rejected his conduct and said this was a bad individual. who've done some terrible things. But what I can't just skip past is when the implication is that the order was signed by Judge Manning because Representative Rutherford was a member or is a member of the Judicial Merit Selection Commission. I can't help but say, wait a minute, Judge Manning was already retiring at that point. He was never coming back in front of the JMSC. Judge Manning had nothing to gain or lose by rendering the decision that he did. Again, let's also acknowledge the legal problems with that case. But insofar as the implication from your statements today is that Judge Manning acted in the way that he did because of Representative Rutherford's status as a member of the JMSC, I don't think that withstands scrutiny. And the same could be said for the lawyer legislator order of protection and Chief Justice Beatty. I'm not here to defend Representative Rutherford, but Chief Justice Beatty is not coming back up before the JMSC. He's going to retire. And so, again, if the implication is that those decisions are only rendered because of the JMSC status of one of the litigants' attorneys, that doesn't work for me. I guess I heard myself talk there. The lawyer legislator order of protection didn't require representation as an attorney there, so let me just recognize I said I misspoke. But Chief Justice Beatty's decision, whatever they were, they're not contingent on the JMSC. And again, I think you raise excellent points about the lawyer legislator order of protection. But I also can't escape the thought that that is the province of the court to issue its orders or not. And you have eloquently articulated the reasons that Madison laid out about the needs for separation of powers. And yet, it seemed to me during your testimony, you took great pride as a member of the executive branch in influencing the judicial branch to issue that order. And so that, at least, is incongruent. Again, I don't want to rush past it and say that I think it's all fine. It is not all fine with respect to lawyer legislator orders of protection. I think it is necessary, as I think you said, that we need to be able, if we're going to have a part-time legislature and we're going to have lawyers who serve in that part-time legislature, there has to be some mechanism for protecting lawyers who serve in the legislature. I'm not here to endorse the current version of that. I think that is worthy of further discussion, and so I applaud you for bringing that up. Consequently, and it sort of goes to my point of optics, I don't want to get into the specifics of any of the cases that involve Judge Coble or Judge Price, because they are both being screened by the JMSC, and as soon as this is done, I'm going to have to run back over there, and for obvious reasons, I can't get into that. But I would be remiss if I didn't point, insofar as we're talking about optics, to the fact that this newspaper article you bring up, at least in several instances, begins with Kringle said. John Kringle, who is a failed political partisan candidate, who is an activist that for whatever reason the state newspaper feels compelled to habitually say, John Kringle, longtime ethics watchdog, as if there's nothing else that can be said about him. So instead of identifying the proponent of the story as more specifically, we just are left with, well, who Kringle couldn't possibly have any motivations in all this. And so, again, I think that goes to my concern about optics. What is the public perceived? Well, what is the public told? And I think it's incumbent upon our friends in the media to make sure that story is told with fidelity to the facts and not for purpose of advancing any agenda. I think it's also relevant here that all lawyers, whether they are legislators or not, are subject to the jurisdiction of the Office of Disciplinary Counsel. And at any time, those complaints can be made and they can be adjudicated. And so I don't think it's consistent with my understanding of how that lawyer discipline process works to suggest that, like, oh man, everybody who saw wrong was left without any recourse. There was no remedy. That's not right. There are remedies available. There are remedies available when a judge acts in violation of the codes of judicial conduct, the canons of judicial conduct. There's a commission on judicial conduct. There is a mechanism for dealing with that. And so I would hate for anybody listening to this to think that, oh, well, we just have to take it because JMSC exists. I don't think that's right. And in the same way, and this is my last point, and then I will give you a brief minute reply because I think that would be pretty chicken of me to not do, but I do have to get back over to the Progressive building. I heard testimony about backlogs and who can call the case and the references to Langford. And Langford was the law of the land, but I think the Supreme Court made very clear in its General Sessions docket management order that was issued on May 24th, 2023, that State versus Langford held unconstitutional a statute giving the solicitor the exclusive authority over docketing and calling for cases. But then in the very next paragraph went on to say the Langford court did not prohibit solicitors from being involved in the docketing process as long as the trial judge has ultimate authority over the setting and calling of a case for trial. Unlike the common pleas docket, one lawyer, the solicitor, is responsible for the prosecution of almost all cases comprising the dockets. Therefore, solicitors have substantial input into the creation of the trial docket. And solicitors have the exclusive control over the plea docket, which I think we would agree is the mechanism by which we handle the overwhelming majority of cases in this state, is through the plea docket. And solicitors alone control that process. And so when I look at the data, which we've not been able to do, or at least we are conflating that with anecdotal evidence, I look in your circuit and see that there are, as of November 1st, 2023, 256 indictments that are over 3 years old. And when you drill down a bit deeper, you see in Orangeburg, murder case that's 3,474 days old. Drug trafficking, 3,000 days old. DUI, felony DUI, 2,970 days old. And on and on and on for a total of 400, these are 431 warrants. So, the same story in Dorchester, 2,205 days old, and on down the list. And this isn't to criticize you in the first instance, because I recognize there's a lot of reasons why cases can't go to trial. Did you have to have, a mental health evaluation? Do you have the DNA evidence back? Do you have various other reports from law enforcement you need to go to trial? Are witnesses available? There's somebody on the run. What I'm suggesting here is, and again, I wish I was able to have a longer and more full dialogue about this. What I'm suggesting is it's unfair to suggest that it's the judiciary that's causing that backlog and that it's JMSC causing that backlog.
What, does he get to go on and make misstatements like that?
That's the way it works.
Okay, good. Go ahead. Keep stating, and then I'll get my last word.
All right. What I'm saying is, if you're suggesting that it's the JMSC that are causing these backlogs, I think that is a misrepresentation of fact.
What is he talking about? Can I go now, Mr. Chairman? Thank you.
And so my question, thank you, Mr. Speaker, my question to you, Solicitor, is what's your reaction to that? I'll give you, you can have it however you want.
If you weren't a Marine, I'd tell you what my reaction to that was. No, I mean, wow. Talk about taking pot shots, whether it's a John Krangle or David Pascoe. And I say this with all due respect. You have absolutely no idea what the docket order says and what it's about, or the Langford opinion. You guys are lost on Langford and the docket order. You want to take pot shots at my office? We just tried a murder case last week, won it, got life without parole. That's what we do.
There aren't many circuits, if any, that have a higher trial conviction rate than the First Circuit. And when we convict them, my judges give them life, whether it's Murphy, Goodstein, or Taylor. But I mean, really, where do you want me to start? You're misstating so many things with regards to the docket. Solicitors have never controlled the docket, especially after Langford. What happened in 2012 after Langford? And I'll address it briefly so maybe you can understand it. We were all walking through the desert, wondrously trying to figure out how to run the docket. And finally, this past year, and to his credit, he's the first and only Chief Justice to actually do it. Other Chief Justices have tried and couldn't do it, and Beatty did it. He got that order done with Justice James's help and others, telling us how to run the docket. That is an order from the Chief Justice telling David Pascoe and other solicitors how we're going to run the docket. And I believe, my opinion, it is a great order. But, I mean, your little pot shots about and who's blaming the JMSC for the backlog? I never did that. I'm blaming the JMSC for the horrible optics of what goes on in this state when the people see preferential treatment go to the JMSC members. And I'm blaming the JMSC for being a rotten commission when they do things to Christy Harrington like they did. That's all I got.
So I appreciate that, Solicitor Pascoe. Again, insofar as my remarks came off as a pot shot at your office, let me take that back. That was certainly not my intent. Sometimes I talk faster than I think. So that's not the intent here. What I'm interested, though, is getting to the truth. And if your allegation is not that the JMSC is causing the backlog, I appreciate the clarification. What I would quibble with you about is the implication that what I read to you out of the May 24th, 2023 General Sessions Docket Management Order is not what it says. I'm not reading into this. I'm reading you verbatim the words that are here. So, again, everybody can look it up for themselves. What the order says on its plain face, it on page 3, 4, solicitors have substantial input into the creation of the trial docket.
And who signed that order?
Chief Justice Beatty, Justice Kittredge, Justice Few, Justice James, and Justice Hill.
That's what they are telling me. Yes, sir. That is their order telling us that and telling the world that. Yes,
So I don't understand how we have a dispute as to what the order says.
All right, gentlemen, I tell you, we got 1 hour left. We can debate the backlog at some subsequent time. Mr. Caskey, I'm going to move forward. I will tell you, members, too.
Yes, sir. Thank you.
Thank you, sir. I've got a number of you that want to ask questions. I have reviewed Mr. Brackett's PowerPoint. It's very similar in subject matter to what Mr. Pascoe had. So I want Mr. Brackett to go ahead and share it because I think otherwise it's going to be Groundhog Day. We're going to be asking some of the same questions of Brackett we asked to Pascoe. Then you can have the opportunity to ask them both questions. So, Mr. Brackett, I know you have a presentation too. Members, if you look at the bottom, the Judicial Reform Committee on the bottom left is in your materials if you choose to look at it on the screen. Mr. Brackett's recognized.
Thank you, Mr. Chairman. I appreciate the opportunity to be here as well. And I want to take just 1 second to concur with everything that that my friend Solicitor Pascoe from the First Circuit said in his opening. We are not here, a couple of things that I keep hearing over and over again, we're here bashing judges. No, we're not. This is not the judge's fault. The judges are put in an untenable situation by a system that is rife for exploitation by a select group of lawyer legislators. And the second point, I said select group intentionally. There are many fine lawyer legislators that work every day in the courts. One of them drives past my office every single day on the way into his office in Rock Hill, and he has never once stopped in and tried to misuse his authority, and I have great respect for the people who could do something but don't. But that does not mean that I shouldn't disrespect and hold in contempt the people who do abuse the authority that they have. The people, some of whom were mentioned by Solicitor Pascoe, and some of whom I'll mention now. Some of those people need to be taken into account, and the system needs to be fixed so that they cannot continue to exploit this. Some of the powers they have, the influence, the ability to intimidate a judge, the ability to stay out of court for 7 months out of a year, that is a marketable service that you can provide your client if he's charged with a crime. I can guarantee you, 7 months, you are absolutely home free. As long as we get to January 1st, baby, you don't have to worry anything until August. And even then, all I have to do is have some legislative function that I'm supposed to attend. We can't even get them into court for the 5 months that's off. We're in the off session now, and you're all here working. So it does happen, but then in the few weeks that we have that we can do something with these cases, we're all fighting to get to them because we've all got old cases with them. And they can't be in two places at once. So it goes on and on and on. And we just have to keep picking up the phone and explaining to the victims why their daughter's case, who was sexually abused, is now 7 years old. That's unacceptable. If you can sit here and conjure up some explanation for how this is a good system, I sure want to hear it, because I can't think of one, and I got a pretty good imagination. I know we have a limited amount of time. You have the clicker over there, would you spare? I don't want to, I'm going to move quickly, because I know we have a limited amount of time, and I want to be available to question. I really do. I'll stay here all day. The cameras can cut off. I'll stay here until you have all your questions answered, because this is a subject that's dear to my heart, and y'all need to know why it needs to be fixed. So I put this on paper. I'm looking down at my slides because when I came in and I looked up there, I was like, I don't know if I'm going to be able to read my PowerPoint. So I had it printed out. It's in front of me. So you see me looking down, I'm looking at the same thing you are. I didn't come here to bash individual legislators. If you want to know who I'm talking, I'm going to mention some because it's just in the context of the story. I can't help it. But I'm not going to bash them. It's not the purpose of this. The system is flawed. I'm not going to mention judges' names, even if you ask me. I'll mention the case, and you can look it up publicly. But I am so determined not to appear to be assaulting the judiciary, who I believe, and my colleagues believe, are the victims in this situation. They are denied. I don't know how they'd rule in cases sometimes, because I don't think they're free to rule as they wish. They're stuck ruling how they think they have to rule. It's the consistent theme. They are definitely under pressure in these situations. No system is perfect. Some are grossly imperfect, and that's what we have here. I want you all to understand, I'm going to go through some cases in a minute, something that the non-lawyers or the people who don't practice in criminal court need to understand. Okay, if you've been practicing in criminal law for 30 years, like I have, like Solicitor Pascoe has, like many of my colleagues have, like many assistants and deputies throughout the state, you know the value of a case, right? If you're a plumber and you've been a plumber for 25 years and your friend says, come over to my house, look at my bathroom, I want to remodel it, I want to put all new fixtures in, you could pretty much say, this is how much that's going to cost. It's going to take me about 6 hours and the fixtures are going to cost this, off the top of your head, because if you've been doing it for 25 years, you pretty much know, right? Well, so do lawyers. We look at a case, we read the facts, we see how strong the evidence is. We look at the defendant. What kind of a record does he have? Is there anything particularly aggravating about this case that's going to outrage the public or outrage a judge's sensibilities when he hears about it? We factor all that in. How old is the person? All these details. We look at that and we go, I think the judge, you tell me who the judge is, that's important too, because different judges have different issues. Judge Justice Beatty, I practiced in front of the chief when he was a circuit judge. Everybody knew. If you had a gun when you were breaking the law and you pled in front of Chief Justice Beatty on the circuit bench, you're going to jail. And everybody knew that. So you need to know who the judge is. But I could look at that case, Solicitor Pascoe could, and we could predict within about a year or two of where we thought the sentence was going to land, and we're pretty dead on every single time, because it's just, after doing it 30 years, you know the value of the new fixtures. So when I tell you these things, some of you might not understand when I say, and here was the sentence. I want you to understand all the people in the courtroom, the public defenders, the private attorneys, when they see a lawyer legislator get a result, they know they wouldn't have got, everybody in the courtroom's looking, going, how did he get a bond on that? How did that guy get probation? I couldn't have got him probation. Clarence Darrow couldn't have got that guy probation. What's at play here? And after seeing it over and over again, you figure it out. The last thing I want to tell you, there was a lot of talk last week about all the work that the bar does. I appreciate all that, and this is not to denigrate them either. I believe they're sincere. As the Attorney General said earlier today, they work hard, and then they see somebody they feel is totally unqualified actually pass through screening and get elected, and they're disheartened. Because it's like, what's the point of all this? We said that we didn't think this person was good, yet they sailed on through and got elected. When I was listening to you guys talking earlier and Representative Caskey questioning him on that, I was like, it reminded me of the old saying, what is the sound of a report that's read in the forest? If nobody's around, does anybody hear it? Nobody listens. If they have made their mind up, and that's the reality of what happens in JMSC, if the candidate is chosen beforehand, the people, they're going to go through without any problem. And it doesn't matter. They'll pass through anybody they want, no matter how bad they are, and they'll keep out anybody they want, no matter how good they are. And that is the flaw. That it's patronage. It is not merit. And I'll talk about that in a second, too. So here's some cases I want to go through, and I'm going to go through them a lot faster, I promise, but I needed to preface my comments. State versus David Morgan. Representative Rutherford was in here a minute ago. That was his case. This was an individual. I have his pre-sentence investigation, and in 30 years, there have only been 2 pre-sentence investigations I've ever even heard of, both of them involving Representative Rutherford's clients. One, the one in Richland that Solicitor talked about, and this one in York. So this is the pre-sentence investigation. He was charged with shooting up a nightclub parking lot. Okay, multiple people out there, and he just opened fire in the parking lot. He's charged with attempted murder and a bunch of other charges, possession of a firearm by a felon and so forth. His record starts at the bottom of this page. This is 6 separate criminal events here, starting in 1987. The crime happened in 2015. Turn it around. This is the other 15 criminal events that resulted in convictions, all the way up to 2013. Okay? He's done 10 years in prison at one point for an aggravated assault. He's done a total of, from 1995 to 2006, he was in the South Carolina Department of Corrections for a variety of bad offenses, robbery, burglary, grand larceny. So he comes into court, and this is one of those cases where everybody thinks, you know, that it's going to be a jail time. Everybody thinks this guy's got to go to jail, and he's going to go to jail for a long time with a record like that and doing what he did. He comes into court with his attorney, Mr. Rutherford, and stands up, and they start talking about, you know, this and that, and then he pleads guilty, and they ask for a pre-sentence investigation. He pled guilty in February of 2017. The pre-sentence investigation was issued, and we couldn't get Mr. Rutherford back until March, the end of March in 2018. Now, the defendant is on house arrest as part of his bond that Mr. Rutherford got him. And under the law y'all passed, if you're in your house under electronic monitoring, you can ask the court to have that applied to your sentence. So he got to spend 15 extra months out of jail in his home, which we showed the court how he routinely flouted that, didn't charge it, nobody knew where he was. It was a joke. And he got a 3-year sentence with credit for 2 years that he spent sitting in his living room for shooting up a club at 2 a.m. With that kind of record. Nobody else could have accomplished that but Mr. Rutherford. Second case I want to talk about, I brought these. Speaker Pope, you will recall, we had a one lawyer who practiced in Union regularly. We could never get him to come to court. We docket his cases over and over again. He's a legislator lawyer from the upstate. He just ignored it. He wouldn't call. You'd call him. He wouldn't call back. It was like he treated court as being optional. It wasn't just protection. He wouldn't come in the fall. He would never come. We couldn't get him to come to court. It got so bad that I would sit there with victims waiting to get called. I would sit there and just say, Your Honor, I know he's not coming. It's obvious he's not coming. His office says they don't know where he is and they don't know how to get a hold of him. Nobody knows where this guy's at. I just started standing up and holding forth on the record and ordering the transcript to try to document this outrage somehow. I found 2 of them, and I'll give those to you. The last one was from 2013. in the case DeMorris Davis, I had told this senator, I said, you pick the day in October. I'll be there any day. I'll have the victims there. We'll do the plea. You schedule it, Representative Bamberg. He had the power of the docket. I just gave it to him. For God's sakes, if you just come to court and tell me when you're coming, we'll do the plea on the day of your choosing. So we all show up on that day. His client sitting on the front row. No sign of him. We call. No answer. I go to the judge. Victims, I got the defendant. What are we doing here? He says, let me have my clerk call him. The secretary at his law firm says, he's not here and I don't know how to get a hold of him. He has my number blocked, I think is what she said, and so that only he can call me. So nobody knew where this guy was. I know, it's ridiculous, it's laughable. So after multiple calls, we finally hear from him at about 2:30. His clerk, the judge's clerk, gets up from behind the bench and holds up his phone and looks at me like, it's him. So I run back. Are we gonna be graced with his presence for a guilty plea? No. He said, I've been busy, I've got a friend who's sick and I've been trying to help him. How dare you call and harass me? To the judge's clerk. The judge's clerk. I could hear him yelling through the speaker on the phone. And he said, what do I have to do? Call Chief Justice Toll? Do I have to do that? And this kid who's like 6 months out of law school is sitting there going, you could see him getting pale. He was horrified. He didn't know what to say. He's just a kid. He was just doing what the judge told him to do. There was a case, I believe, I was reminded of, where the guy he represented was sitting in jail. We had a time served offer. This guy could have got out of jail if he would just show up to do the plea, and he sat in jail for an extra 7 months because we couldn't get him there to do the plea. I had forgotten all about that. There's no way you can tell me, because no other lawyer, if I'm 15 minutes late, I feel bad. But there's no other lawyer. If a public defender just stopped coming to court, do you think that would be the result? Everybody just shrugs and goes, well, what are we to do? This same fellow represented an individual in Greenwood. I'll try to tell you that story, but before I do, I want to go back to Representative Rutherford. I'm sorry he's a target-rich environment, but he keeps on giving. This was a case that happened in the 11th Circuit, Solicitor Hubbard told me about. In this case, they again told him this was an old case. They tried to schedule it for trial. They finally said, just give me, here's the 2 dates in October, the 2 weeks we have court. Pick one of them. We'll try it then. So he picked the October 15th. They get to 2 weeks out, and he files a continuance motion and demands to be heard. He says, I was never notified of this trial. I have no notification of it. This was the cookout killing in Lexington. It got a lot of press. 18-year-old kid stabbed in the chest one time, right in the heart. 18-year-old kid lured over to the car. The guy in the car had a beef with him. Kid had done nothing wrong, just lured him over there and one shot out of the window with a knife and killed him right there. They found the knife buried in the neighbor's backyard of the defendant. He called over and said, I had no notice. When Solicitor Hubbard stood up and held up the email and said, here's the email you sent saying October 15th, you picked the day. He looked and said, are you calling me a liar? And told him to shut up and sit down. The judge said, well, maybe the email went to the wrong address. To which Solicitor Hubbard said, well, how did he reply then? How is it possible that he replied with his signature on there? How is that possible? Obviously it didn't go to, but the judge was so concerned, he didn't want to say anything to upset Mr. Rutherford. So he just eventually, after talking, they said, well, we'll schedule the hearing for the continuance for October 24th, 9 days after the trial was supposed to start. So we're giving you the continuance by scheduling the motion for after the fact. My lawyer from Union, I'm trying to go through the facts really fast. A guy charged in 2 murders and attempted murder. This is Jeremy Trevios Saxon. horrible, horrible gang member up there, multiple drug distributions, assaulting police officers while resisting arrest, throwing urine on detention center officers who, thank God, we have people willing to do that. It's a hard job. Horrible person. He's arrested, taken to jail, and they dicker back and forth with the public defender trying to get it to trial. Couple of years into the case, they finally get a trial date, and they're prepared. A week before the trial, the legislator lawyer comes down, files a notice, which happens too many times. We're all ready to go to trial, and the legislator lawyer comes in, files a notice saying, I represent this guy. That's an automatic, guaranteed continuance. The case will be put off, and sure enough it was. He managed to wheedle and cajole and talk to 2 different judges over the next 6 months, and finally got this guy who has a terrible record and was charged with stabbing a man in the throat, nearly died, but for immediate medical intervention that was fortunately close by, that guy would have been dead. The guy got probation. Again, looking at results that nobody else would have received. This gang member, and the victim survived in that case, but as a sad postscript, he was murdered shortly after that by another gang member from the same gang as Mr. Saxon. The criminals know that you go to a legislator lawyer, and that's who's going to help you. They all know that too. We had 30 kilos of fentanyl seized in York County last year in the fall. 30 kilos. These people had real property that they owned, houses, land. They owned fancy cars. One of them was wearing a $100,000 Cartier wristwatch, lots of money. The top 3 guys, the ringleaders, all 3 of them hired legislator lawyers, one of whom was on the JMSC. They know who to go to for help, but in a happy postscript, we got the case moved to federal court, where a federal judge doesn't give a rat's butt about whether you're in the legislature. When they schedule a case for trial, you're going to be there. So that is a good contrast with the problems we're talking about. There's so many problems. We actually had to pare this lift. You can't imagine how many stories were left on the cutting room floor. And I feel bad. I know my folks are working hard right now. We're trying cases. Oh, Mr. Caskey isn't here. We just got a verdict about 45 minutes ago on a homicide by child abuse case, a guilty verdict on a 4-year-old case. We're working hard to clear the backlog, and we actually have our numbers down to what they were right at the time COVID hit. So we're awfully proud of that. We've had incidents where legislator lawyers come in and tell the judge, I know what the legislative intent was, Your Honor, when this statute was passed, because I'm in the legislature. Countless stories of legislators coming in and talking to judges and saying, say, Judge, aren't you up for re-election next year? What would be the point of that? Why would you want to do that? Except to remind them who holds the whip hand, who is in charge here. All the way to stories where legislator lawyers walk out and tell you, here's what the sentence is going to be on this plea we're about to do. And I don't know how they knew that, but it was awfully coincidental that the judge came out and gave a sentence that was exactly what the legislator lawyer said it was going to be. I'm not a witness to anything, but he's either awfully good, he's Nostradamus, or so. Those are the cases I want to talk about. The last one I want to talk about is State versus Hawthorne. And this is, for me, a great example. The thing you need to know about State versus Hawthorne is he was charged with the murder of Larry Vaughn, a veteran, retired police officer, a lieutenant who just retired recently from the Rock Hill Police Department, found beaten to death in his apartment. Mr. Hawthorne was arrested shortly thereafter. Fortunately, there were witnesses who were able to identify him as being at the scene. They found him. He still, they were able to gather good evidence and make a quick arrest on the case. He hires Jack Swirling. For those of you that don't practice in the criminal field, Jack Swirling, if you have him in your corner, it's like having, you've got the Muhammad Ali of the criminal defense bar fighting for you. He's a great lawyer, has the respect of everybody on both sides of the courtroom, prosecutors and defense. Everybody likes Jack, and everybody respects Jack. He is feared. He is a great lawyer. So he hires a good lawyer to go and represent him. Jack takes him into court, tries to get him a bond. No bond. Terrible crime, brutal beating, bond denied. Some months go by, and all of a sudden, we get in November of 2022, an email from Mr. Rutherford's law firm saying that they want to schedule a bond hearing. We didn't know Mr. Rutherford was even involved in the case. We found out about it maybe a few weeks before that, but he just popped up for the purposes of trying to secure him a bond. Not only does he want a bond hearing, they tell us exactly what day they want the bond hearing and that they want it in the morning of that court week, Tuesday in the morning on the 13th. So obviously, victims have rights too, believe it or not, they do, and we have to notify them and people who want to be there. And Jack Swirling has rights because he's the guy's lawyer. He's the one actually listed as being his attorney. So we noticed that Jack is not, well, we don't, because I conflicted the case to the Seventh Circuit. Solicitor Barnett's office is handling this case. We noticed that Jack Swirling isn't listed on that request for a bond hearing, so he's added to the thing, and Jack comes back and says, I'm in a murder trial that week, I can't do it. So we think it's off, if Jack can't be there. Todd writes back and curiously deletes Jack's email off of that email list. He's not listed on that. Writes back and says, Mr. Rutherford is waiving Mr. Swirling's presence. Spencer catches that, Spencer Smith, the attorney prosecuting it, and says, what about Mr. Swirling? Is he waiving his presence at the bond hearing? Because I think we need to hear from him. And Jack says in a subsequent email, apparently they want to move forward even if I can't be there. I will waive my presence, assuming I can get a written request from the defendant and his parents. Thanks for checking with me. To Spencer, because nobody else checked with him. The next email we get is December 1st. Here is the waiver. We don't need Jack. So we start to go forward. I reach out to the victims. I'm doing the victim piece. I call the victims. The daughter of the dead police officer is in college, and she's in final exams that week. So the family says, please, can you put this off? Even talking about it's going to disrupt her exams. We're afraid it's going to have a bad impact on her finals. She's very upset about the whole thing, understandably. Please, can we get this delayed to a later date? So we tell them that, Mr. Rutherford's office, and they say, and in addition to that, I wanted to be there, and so did Sheriff Tolson. We tell the defense that and say, look, the child can't be there and really wants to be there. She's in college, final exams. It doesn't matter. All they're entitled to is notice, they say. I'm going to call the administrative judge. Now, there was no email from the administrative judge, but at some point that week, I was told, that I could tell the victims to stand down. The chief administrative judge said, we're not going to have the hearing if the child can't be there. So I told them that. Then at Friday at 3 p.m., I get another email saying that a visiting judge who is also going to be there that week has been contacted and has said that he will hear it. I call the chief judge back and say, wait a minute, you said we're not going to do this. I've already told the family no. And he says, well, I don't want to step on this other judge's toes. And I had to think to myself, does he not want to step on the other judge's toes, or does he not want to step on Mr. Rutherford's toes? Who's really, who's he worried about offending? Because he's up for re-election as well this year. The hearing went forward. Bond, which had previously been denied, is set. The defendant is released. No change in circumstances, nothing to justify a new bond. Then we find out from jail calls between the mother of the defendant and the defendant, we hear her version of her conversations with Mr. Rutherford. She says, Todd says we just need to be patient. We're waiting for the right judge. And it's good that Todd has connections. I wasn't a party to that conversation, but everybody who heard that in the law enforcement community immediately said, what kind of connections does he have? And does he have influence over a judge? How is it that this man couldn't get a bond with Jack Swirling, but Todd shows up and all of a sudden he's going home with his mom? And what do these calls mean? Perception is reality. And as I think you said last week, Mr. Speaker, it not only has to be right, it has to look right. My last these are all the emails. You have a copy of this PowerPoint, so you can see them. I can't read them from there. The last case that I want to study, this is Christy Harrington on the left and Judge Tommy Russo on the right. And I'm grateful to have Judge Russo in the room with us today. He came here, and I'm sure he'd be happy to talk to you about his experience with JMSC. His JMSC hearing was set. He was a great judge. I practiced in front of him. I never heard a single bad thing about Tommy Russo when he was on the bench. Everybody respected him. He had a good temperament. He was efficient, worked hard, showed up, worked all day. Everything you could possibly ask for in a judge. He was up for re-election in 2019. The election would have taken place in early 2020. But his screening was set for November the 18th of 2019. Nobody had filed in opposition. There were no complaints. He met with the staff attorney assigned to his case the month before his screening, in mid to, first, maybe second, third week in October. No issues. Asked a few questions about some of the things on his application, but in his mind, it was the same as it had ever been. I think he'd been screened 3 or 4 times, and there was no indication that there was going to be a problem at all. No, they're going to really grill you about this. Everything was fine. They're probably going to ask you questions about that, but you just tell them this, and this is all good. So he's thinking it's great. But there were issues. On the right is an order that he signed in a case, Larios versus the estate of Larios versus South Carolina Electric and Gas, a case out of Colleton County. I'm going to talk about that for a minute. Larios was a case that Judge Russo presided over. It was a wrongful death action. An individual who was a landscaper from Mexico had been electrocuted, and the case was tried in Colleton County in front of Judge Russo, and a $21 million verdict was rendered for the plaintiff. It was tried by a firm out of Charleston. Just no legislators involved in the case whatsoever, all the way through the verdict. September 27, $21 million. October 8th, the defendant files a motion for a new trial. Basically, a motion for a new trial is, let's set that aside. This can't be right. We need a do-over. This doesn't make sense in light of what the facts were in the case. This is way too much money, and this needs to be reconsidered. I want a new trial. On October 18th, the chairman of the JMSC, Representative Merle Smith, was hired and made an appearance in the case for the first time. Had no idea about the facts of the case prior to that. He wasn't a trial lawyer in the case. He had no involvement with it whatsoever. But suddenly, he's hired to litigate and defend the $21 million verdict and try to protect these lawyers' $21 million winning from being overturned in this motion for a new trial. The next week, the motion for the plaintiff is argued by Chairman Smith. On November 1st, Judge Russo issues an order granting the motion for a new trial. In other words, ruling against the chairman. Now fast forward to the screening day, Monday the 18th. Judge Russo shows up for his screening. Still nothing unusual has been raised. Nobody said anything to him. But for some reason, the chairman has recused himself. Thank you. For some reason, the chairman has recused himself from participating in Judge Russo's screening, which is odd because they have no other connection that would justify that. But he's not there. They ask him a few questions about a disciplinary complaint that had been filed against him regarding a Facebook post. And they say, would you mind, and it's fairly friendly, the conversation on the 18th, would you mind very much allowing us to look at 6 years of your Facebook history? We want to look back through that. And while we're at it, would you mind getting and allowing us to see the disciplinary counsel's record? Now, you heard about the disciplinary counsel from Solicitor Pascoe. What he didn't explain is the disciplinary counsel is to lawyers what the boogeyman is to children, okay? That's the scary monster hiding under the bed who's going to grab your ankle if you get out of bed. This is the man who can take your law license and deprive you of your ability to make money. The disciplinary counsel is somebody you never want to get a letter from. So, you know, it was, I think that's important context for his story, and you need to understand that as to why it was unusual that he was at Christy Harrington's screening. But they asked to see the file, and he said, that's fine, I got nothing to hide, and here's my 6 years of Facebook. I don't do a lot on it, but take a look at it. And the Facebook post that they were concerned about was some post that he'd made, not on his own Facebook, but a comment in reply to somebody else's, which basically said, people are hypocritical. You know, that they say one thing here, but then they do another thing there. It wasn't, as postings go on Facebook, it was tame. So he says, fine, and they say, great. And the other thing that's unusual you need to know is that when he got there, after they asked a few questions, they went into executive session, which there's nobody here now from the JMSC, but I don't know why you go into executive session if you're the JMSC. I thought if you're a public body, you only go into executive session to get legal advice, to discuss a pending contract. There's very few things that you can go into executive session, but they kicked everybody out. And they stayed in executive session when they told him to come back on the 18th. They said, you know, come on back on the 18th, or the 20th rather, and we're gonna have further conversation after we've reviewed your Facebook posts. He comes back, they're still in executive session, and the assault on him begins immediately. Just like Solicitor Pascoe described for Harrington, they attack him, they ridicule him, they berate and condemn him, call him all sorts of horrible things, and after beating on him for an extended period of time, Mr. Rutherford looks at him. There's been no vote, there's been no deliberations, nothing. Mr. Rutherford looks at him and says, you're not making it out of screening. The only thing you have to decide is whether you want us to come out of executive session and humiliate you in public, or you want to withdraw. And he is shell-shocked. He can't even think. And he says, I need to talk to my wife. And they said, we'll give you 5 minutes to discuss whether or not you should end your judicial career, a distinguished judicial career. 5 minutes, go call your wife, and then come back and tell us what you want to do. Because we're moving on. So he withdrew. He surrendered his robe. And now I don't know what motivated this sudden change of heart. Why did they all of a sudden have problems with him when a month before everything was on cruise control and he was coming in for a soft landing? I have no idea what goes on in people's minds, but perception is reality, and it not only has to be right, it has to look right. And I ask you, does this look right to you? 3 weeks after he shoots down a $21 million verdict that's being defended by the chairman of the JMSC, his legal career, his judicial career is in tatters, and he is flamed out, blindsided. You got them. Yep. Hit it. He was replaced a year later by a man named Stephen DeBerry. I never practiced in front of Stephen DeBerry, maybe a fine fellow, I don't know. But he was elected the next year to replace Judge Russo. This was an article written by John Monk with the state newspaper that he went to cover the JMSC hearings for Judge Russo's replacement. 14 people were screened, 3 came out, including Mr. DeBerry and 2 other individuals. And as I said, Mr. DeBerry won. Go ahead. Mr. DeBerry, a Florence lawyer and member of the Florence County Council. DeBerry is first cousin to Representative Smith, the chairman of the JMSC. Must be right, must look right. I don't know what's going on. Maybe he was the best candidate out of the 14. But how do you think that looks to the public? How do you think it looks to Judge Russo? Interestingly, in a rare moment of candor, complete and total shocking candor from Mr. Rutherford, talking about the JMSC process, he says, if you find a lawyer coming in here that doesn't have connections, I promise you they won't make it out. We have a small legal community. If somebody came in here and didn't have a connection to anybody in this room, it would be odd. I don't know how they'd make it out. What in the world? In that brief shining moment, Mr. Rutherford kindly showed everybody this is what it's about. And in a beautiful lead paragraph from Mr. Monk, hit it if I think it's the next. I read this and just had to laugh out loud. This is his lead. Ancestors, family pedigrees, old friendships, college ties, easy cheer, and even merit were all part of the mix last week. Like, hey, they even talked about merit. But just like Mr. Rutherford said, it's not what you know, it's who you know. If Mr. Rutherford's right, and I submit that he is, Benjamin Cardozo, learned hand, Antonin Scalia, Ruth Bader Ginsburg could all submit for judge in South Carolina, and they wouldn't stand a chance, because none of those people know anybody in that room. So what do we do? Again, I don't know how you defend that, but what do we do? How do we go forward? And I know you want recommendations, and I know the three areas of concern, and I appreciate the fact that this commission exists to have these public hearings. So, as far as magistrates, and I'll say I have not had time to sit down with my colleagues and discuss all this stuff. We had our solicitors conference and we're meeting next month, but I haven't had a chance. So this is Kevin's opinion on what we should do. Some of my colleagues may disagree, but I
think you provided this to staff, but it was today. I'm not sure that,
That's
that
right.
members have a copy, but I'll make sure that all members get a copy of the recommendations.
So, and I've talked about this before, I believe, with you, Speaker Pope. We've talked about, how could we change things? How do we make things better? Well, General Sessions Court is overrun. We've got a lot of cases in General Sessions Court. That's why our dockets are as bad as they are. We have a ton of smaller cases that are there, 3 years or less. I think that magistrate court should follow, and we should follow what other states have done, many other states, and create an intermediate court with a jurisdiction up to 3 years. Call it a district court. And that the district judge needs to be a lawyer. They can hear all those cases can be taken out of General Sessions Court and shifted down to district court. Allow the district court judges to hire magistrates who can hear the smaller cases, 30 days, just like we have now. But their jurisdiction would be limited to 30 days or less, and they don't have to be lawyers. They could run traffic court, in other words. The thousands of tickets that roll through our magistrate courts throughout the state. I think the number of judges in a county should be dictated by population so that you can look and see how many people they have. This is about how many district judges they need. District judges should be hired by the senior circuit judge and supervised by that person. Then they're only accountable to another judge. That judge makes sure the cases are being moved in a timely fashion, and you can establish evaluative criteria. How about that? We say, how long does it take you to move a case in court? How quickly are you setting bonds? Are you getting warrants out in a timely fashion? How many trials do you have versus pleas? The next one, JMSC, appointed by the governor. I'm going to talk a little bit more about the JMSC. I think the governor needs to exclusively control who's on the JMSC and the screening function. And I'll talk about this as I go into my next page as well. I think you could have term limits, and I'm sorry Mr. Caskey isn't here. I enjoyed his line of questioning with the Attorney General earlier today. Term limits for members would solve a lot of the problems that they were talking about. Why don't we have retired judges and senior members of the bar who are retired after long and fruitful careers practicing law? Let them screen judges. They're not going to go back in front of them. Let those guys screen them and have a pool of them, 25 or 30. And nobody knows who you're going to screen until you show up. And they say, here you go. Here's all the stuff. We're putting 3 of you on this judge, 3 on this judge. Let them screen them and then term limit them out so you're never screening the same judge twice. Make sure that they're open and televised. The public should be able to see these. No executive sessions. Nobody should go through what Judge Russo went through. You could consider possibly just making their positions advisory only that doesn't kill the candidacy, that it still comes forward for consideration. And lastly, consider extending the period of time for a judge, the term, from 6 to 8 years. And there's a good reason for that, and I'll tell you in a minute on the next slide. The election process, the issue isn't the selection process. The issue is the reselection process. Every judge in this state knows they have to come back to the legislature every so often and beg for their job. That is the sword of Damocles that hangs over every judge, and that is the authority and the power that certain legislator, lawyers, JMSC members have to exploit their influence over these judges and influence and pressure them into getting some of the results we've been talking about. Once you've been chosen as a judge, you should not have to come back to the legislature. That solves all the problems. Now you're on the bench, and you should be accountable to one of two different scenarios. Scenario one, which many states do, is a retention election by the public. I trust the public to make these decisions. They elected all of us, right? Why shouldn't they be trusted to decide whether their judges are doing a good job? This isn't a contested election. People keep saying, it's contested elections they want. This is terrible. We're going to do like North Carolina. Money's going to corrupt the process. We're not talking about a contested election. Up or down, should we keep this judge or not? And if they say no, it goes back through the process, screened again, chosen, preferably by the governor, but possibly by the legislature, and then back out to serve until the public says you're not doing a good job. You could also extend the term to 8 years, as I said earlier, and let the governor reappoint instead of retention elections. That way, since you're term limited as a governor, you only ever get one crack at a judge. You never can influence them again. Once you've reappointed them, you're done. Although I'll say, I think the threat of governors abusing their system and influencing judges improperly is kind of overblown, because in my 32 years, I've never seen a governor walk into court with his arm around a client and a briefcase in the other hand to litigate his case. So, reselection by the legislature is the persistent threat to judicial independence in South Carolina. Hamilton Federalist 78, just because everybody else talked about 51, I think 78 needs to get a little play, so I threw it in there. He's quoting Montesquieu, and this is Alexander Hamilton. I agree that there is no liberty if the power of judging be not separated from the legislative and executive powers. And it proves in the last place that as liberty can have nothing to fear from the judiciary alone, but would have everything to fear from its union with either of the other departments. While still not perfect, retention elections or subsequent reappointment by successive governors offers the greatest degree of judicial independence, short of life tenure, which I say I wouldn't want life tenure either for South Carolina, but I'd take it over what we have now. Lastly, on the way of suggestions, the vesting clause of Article 3 from the United States Constitution, the highlighted part, just talks about setting up courts and so forth. But the last part was really interesting. And these judges shall at stated times receive for their services a compensation, a salary, of course, which shall not be diminished during their continuance in office. Can't cut their salaries, because the Founding Fathers recognized, well, they might not be able to run them off if they have life tenure, but if they cut their salary to $1 a year, they ain't gonna stick around long, because they gotta eat. So they protected them from the power of the purse. And I believe that is another thing that the legislature can do to protect the judicial independence in South Carolina. And that is making sure that the judicial budget is never less than the previous year or a set percentage of the total budget, whichever is greater, so that they can never be punished for not doing the bidding of the legislature. The legislature has to set the budget. That is a proper function of a legislator, levying taxes and appropriating money. But to cut the budget and punish somebody because they don't do what you want, or even have that threat. Because it was previously asked by Mr. Caskey and Mr. Pascoe, why would Justice Beatty worry? He's not going to have to come up for re-election. No, he's not. But that was January. What happens in January in the legislature? It's the start of budget season. And who comes over here? Who represents the unified justice system in South Carolina? The Chief Justice. His office is the one that has to fight and scrap for money, just like every other agency. So making sure that they can't be tampered with. Now, of course, if times of lean come and we have another great recession and cuts have to be made, cuts have to be made. As long as the cuts aren't made greater than anybody else. As long as they're equal to everybody else's. So it's not like, oh, we're gonna cut SLED 5%, but we're cutting the judiciary 30%. That wouldn't be acceptable. So I think providing some mechanism to protect the independence of the judiciary from influence through the power of the purse. I just have a few closing thoughts, and I don't even know how much I've blathered on. I have 15 minutes for questions. Yes, sir. Yes, sir. I really, the public, in light of recent events, is justifiably outraged. Everywhere I go and talk about this, they are concerned. And when they finally, the ones who don't know about it, when you explain it to them, they are red-faced. They can't believe that this is the state of affairs in South Carolina. As bad as the system is for screening, as bad as that is, the patronage is just as bad. Family members, it can't be a coincidence that so many family members of legislators end up in judicial positions. If you have any reservations about whether or not the system has any value, I would ask you to think about Solicitor Pascoe's description of the events at Christy Harrington's. The fact that Chairman Rankin or whoever had a staffer call over to the Supreme Court and summon the disciplinary council to a hearing, sit him in that room, see him in the back, and say, no, come up and sit up front so she can get a good look at the boogeyman. You get up here. Literally sat him up front, staged him like a prop on the set of his show hearing, is not just clear and convincing evidence, it is beyond any doubt the arrogance and contempt, the sense that they are above the law, that they could do that. Calling the disciplinary council, an officer of the Supreme Court, and bringing them over there to intimidate a judge is appalling. They say the only thing necessary for the triumph of evil is for good men to do nothing. You are at a fork in the road. If all you end up doing is adding a couple, 3 people that the governor can appoint, maybe increasing from 3 to 5 the number of people who get reported out, you're just rearranging the furniture and putting another coat of paint on the walls. You're changing nothing. Even if you took all the legislators off the JMSC, but left the appointment power in the legislature so that they're the legislature's people, you do nothing. You actually make it harder for us to figure out what's going on because they have one layer of insulation from accountability. It's not them doing it, it's their stooge. That would be unacceptable too. The legislature needs to divide the responsibility for selecting a judge with the governor's office and then put the power in the hands of the people to decide whether their judges are doing a good job for them. Thank you.
Ladies and gentlemen, so we got about 15 minutes from that hard stop. We're 15 minutes past our 2:30 hard stop. We're heading to 3. I'll let you know when it's 3 and we'll figure out where we are from there. But Ms. Wetmore is recognized.
Thank you, Mr. Chair, and thank you, Solicitor, both solicitors for joining us as well, and recognize Solicitor Scarlett Wilson here as well. Thank you all for being here and for your interest in this subject. I know a number of solicitors, of course, Scarlett's my solicitor. So I want to start by asking, well, let me start with a caveat. I think all of us up here, we've said this over and over again, we want the same thing. Solicitor Pascoe, I hope you unintentionally mischaracterized my comments earlier. I'm not questioning whether or not Democrats want change. I think we all up here want something, and I think we're all committed to taking some actions here. What I'm trying to question is whether or not we're going to create any new problems based on the changes we make. And what I'm trying to avoid is making sure that we don't unintentionally create a new and different problem with any of the proposed changes. So I'm trying to vet those changes as carefully as we can. I heard you talk about if the legislature has appointment power, it would be a stooge. To me, that speaks exactly to my point with that appointment power moving somewhere else. I don't understand how, I recognize, I think having maybe, a retired judge or two, that makes sense to me. But at some point, either because they are members of a firm, someone always has influence. A retired judge is going to have members of their firm before them. A retired attorney is going to have members of their firm behind them. They're going to have their kids. They're going to have, if it's the governor's office, they're going to have their staff or their appointees. At some point, someone always has influence. And so what I'm hearing is that we don't like the who. It might help me understand how we can avoid, in the scenarios you've laid out, someone having influence.
Well, it's always possible, and all you can do is minimize it, which we can certainly do a better job of minimizing it from what we're doing now. But what I think you could do, there's multiple ways you could skin the cat. One of the things you could do, for example, is create pools of senior retired lawyers and retired judges, upstate, Midlands, Low Country. And if you're in the Low Country, you screen the judges who are applying from the upstate, and you're picked at random. Yeah. You don't even know which judge you're going to be screening until you walk in the room, and then the judge walks in and sits down.
I like that.
The ability to come in and influence those three people when they don't even know who it's going to be is greatly minimized, especially from what we have now.
Yeah, see, that's constructive. Thank you.
Yes,
second question would be, I hear a lot of talk about this idea that there's the opportunity for influence or the appearance of influence. And I think all of the cases that you've named, or a lot of them anyway, there's an appearance for everything we do. I mean, you and I are both elected publicly, and I think we would probably agree the worst part of that is fundraising. Is there an appearance of influence when I meet with a donor, if you meet with a donor, right? I just think that to say that the appearance of influence, at some point, don't we have to trust that there are backstops, that there is the ODC, that we do have an ethics process or these judicial discipline or lawyer discipline, all of the scenarios you've described, just like when, someone comes to me and they say, this person was unfairly killed in the jail. I don't know, I'm just using an example here. Well, we have a process for that, right? And I encourage them to go through that process, right? If it was illegal, then they should, then the justice system will handle that. Just like if, here we have a process, wouldn't strengthening that process more effectively address the egregious cases you've described today?
I don't think it would more effectively address it. I think that strengthening those processes is a good thing and should be done. I'm not suggesting that in any way, shape, or form, but I don't think strengthening those processes alleviates us of the responsibility from removing the infirmities that exist in the existing system.
Okay. I'll ask you the same question I asked Attorney General Wilson. When did we start trying to be Washington, D.C.? I mean, if you had told me that we would come into this hearing today and say that the South Carolina Constitution had just gotten it flat wrong, I've never heard us have that conversation in any other context of saying, we should do it more like the federal system. Is this the only issue in which the South Carolina Constitution has just got it flat wrong?
Well, I don't think we're trying to become more like the federal system. If we were, it would be governor appoints, legislature confirms, and a lifetime tenure.
But I mean, we agree that since the 1700s, the South Carolina Constitution has put the power for electing judges within, and because of the history of our state, squarely within the power of the legislature.
I think
Article 5 in several different sections.
Maybe the 1895 Constitution.
It was in the 1737 and the
Well,
1767.
you read the article. I'm sure that
Yes,
you probably know
yes.
better. Dean Wilcox is a smart guy. I'm sure he drilled down on that.
Yeah.
But I don't think that just because Washington has other problems doesn't mean we can't look to them for good advice on some things, and especially when our system that we currently have is as deeply flawed as it is. I don't think we should just look to Washington. Unfortunately, we're not going to hear from Professor Fitzpatrick, whose area of expertise is judicial selection from Vanderbilt Law School.
And was in fact my professor in law school, so
Was
thank
he
you.
really?
Yes.
Yeah, super smart guy. I felt smarter just reading his biography. I mean, the first in his class in Harvard, clerked for Justice Antonin Scalia, obviously a very capable man. So, the Tennessee just completely revamped how they select judges. They've done a lot of spade work on this, and I'm sure they have a lot of useful information they could share. We don't just have to look to Washington. We could look other places, but there are many, many states that do it just the way I described. It's called the Missouri Plan, and the governor selects, legislature confirms, and then people ultimately up or down in publicly funded elections. Oddly enough, in many cases, the government funds and gives the judge a certain amount of money to make the case for why they should continue, so the judge doesn't have to raise money.
And I'm not disagreeing that there are other models, some better than ours, some worse than ours. What I am saying is that since the beginning of our state, this is the way South Carolina has done it, and I've just never before heard us say so clearly that we just got it dead wrong. And I hear you, and I think it's up for debate. I think certainly some of the changes you're suggesting would require constitutional amendments. I don't know if that's within the scope of what we have the ability to handle right now. All we can handle are statutory changes. But certainly, I'm just surprised, I guess. It's more of a comment than a question.
We do have a general election coming up next year, so constitutional changes are in the, they are possible. So it could happen. I mean, I would say something that Solicitor Pascoe said. It definitely, I think, part of the problem is there's been this climate of fear. Nobody wants to talk about this sort of thing. And just the recent events of the last year, one after the other, cascading, coming down, has just driven the issue to the front. And people are starting to go, what in the world is going on in these courtrooms?
Well, and listen, I was a prosecutor when it was very trendy to accuse prosecutors of misconduct. I'm sure you were there too.
It still is.
Because of cherry-picked stories in the media. And so I would certainly submit that on the whole, to me, in my 15 years in the courtroom, it seems like we're getting it right. It seems like it's easy to drive a narrative of fear if we want to. And so I would submit that just like prosecutors get attacked unfairly, we have to very carefully look. The reason we keep asking for data is because we have to carefully look at the bigger picture.
Can I address something, Representative Wetmore? I've got a very good crackerjack law clerk by the name of Alan Wilson, and I had him text me some information. With regards to the JMSC, let me just get one thing clear. That's relatively new. That hadn't been around since the 1700s.
No,
That was
1975. Yes.
1996. And
The bar had it
ratified
in 75, you're right.
and ratified in 1997. And we're just talking about the first step today, which is the easy step. And again, I don't understand why it's difficult when you hear stories about Judge Harrington and Judge Russo that we need to change the JMSC. All we're asking for today is take the legislators off the JMSC. That's it. It's a very simple fix.
I think you and Solicitor Brackett might be asking for two different things.
No. He went further. He's much smarter than I am on that stuff, so he's telling you what to do down the road as well.
Fair enough, but what
for
my
today-
questions were directed at were not simply that one simple fix.
Absolutely. But for today, what we're asking for is to take away legislative control from the JMSC, which is a relatively new thing.
Thank
That's
you.
certainly the easiest thing. It could be on the governor's desk by the end of January if the will was there.
Thank you.
Brackett's going to snatch defeat from the jaws of victory if he keeps on, I think. Okay, so our next questioner is Mr. Bamberg. I've never known Justin ask a 3-minute question, so we have woefully underestimated our hard stop at 2:30, even 3. I know members have places they've committed to and they have to be. I appreciate it. I gave you guys free rein to escape, and some of you even made the mistake of coming back, General. So I think in talking to my co-chair, Weston Newton, and we'll get the feel for the panel at some point. We've got Thanksgiving next week. I think we will then come back the 24th. That was the week, the day we were originally going to do citizen hearings. I think we will try to put in a full day, and is it 28th? 28th, my bad, 28th. Yes, committee, I will buy you some lunch if you will come and work all day. So I just wanted to I had another pack of crackers, Gilda, if you keep it up.
Jelly donuts.
Jelly donuts, yeah. So anyway, what we'll try to do, if you guys are willing, and we'll coordinate with staff, I'd love to hear from the professor, see how Wetmore did in class. And we would like to maybe start again at 10 o'clock, and we'll work into, some point in the afternoon, we'll take a break, and then later afternoon, try to have the citizens. But for those of you that are willing, obviously you got enough interest, you stayed, so if you guys are willing to come back, we'll keep plugging. And if that meets, I would love for us to get as much done the next committee meeting as we can. And then our idea is either that easy work we do, according to Mr. Brackett, we'll either rewrite the Constitution or change all the laws over Christmas, and then we'll have it ready for the governor's signature January, 2nd-ish? Is that all right, Mr. Brackett? Yeah.
Somewhere in there.
Okay. Yeah, we got to actually come back in session first to pass it, I guess. I appreciate everybody's participation. I'm telling you, we would not be here. I told the speaker early on that if we're just going through the motions, and I've shared with some of the folks in the audience, if we're just going through the motions, Ms. Cobb Hunter and I were talking about, I don't want to do it. If we're just going to be here and just talk about it and then do the same thing. I did that for 10 years on tax reform. I ain't got another good 10 in me. So our intention is to do something. There's no doubt some things are heavier lifts than others. There's some things reasonable people can disagree. I'm assuming after all the things we heard today, we're going to hear more from people off the record, and that'll continue to be. But our intention is to work on it to, in my perfect world, we draft something up that we could present on the House side that would go through judiciary and then hopefully get it over to the Senate. And so we're going to continue to work. I appreciate everybody. And again, we will even keep solicitors if y'all are determined, if nothing bad happens to you in the next couple of weeks. We would even just pick up with our questions where we had left off if the members are willing, if you wish to return. All right. Thank you, guys.
Down here in the pines, where the backroom deals get sold, they've been trading our trust for silver, like the people don't ever get told. But Pascoe's coming up the road, boots on the ground, heavy load, yeah, shining a light where the shadows grow. David Pascoe, South Carolina's own. He stared down the good old boys, looked power straight in the eye, said you answer to the folks back home, or you pack it up and say goodbye. Oh, 'cause Pascoe's coming up the road, steady soul, cleaning out that Capitol gold. David Pascoe, South Carolina's own. Pascoe's coming up the road for the people. That's the oath he holds.